Thanks. Good morning, everyone. It's my pleasure to speak today on trends in transportation from a legal perspective. The agenda for today is for me to talk about contracts generally. We'll be looking at specifically employment contracts, and then we're going to look at force majeure in contracts. Talk a little bit about trends this year in cargo claims and bills of lading, and then also some insurance issues that we see happening this year. So the major issue this year in terms of trends is contracts. I think COVID-19 has resulted in everyone looking at their contracts, whether they have issues in delivery or have issues in getting drivers. Everybody's looking at contracts. So this year we must get inquiries to look at 5 to 10 contracts a week. So in a sense, from a legal perspective, it's been COVID hasn't been that bad, although you'll see from my comments later that the court system is kind of bogged down. So we've been looking at shipper-carrier contracts, broker-carrier contracts, all the way down to insurance contracts. Everyone involved in this industry is examining their contracts. I guess the starting point is the 2010 Supreme Court of Canada case in Turcon, where the court essentially says there's freedom of contract. What freedom of contract means is that sophisticated parties are entitled to contract as they see fit, and the courts will not interfere in those contracts. So we have a series of cases starting in 2010 with the Turcon case on freedom of contract, and then we have a number of 3 Supreme Court of Canada cases talking about how you interpret contracts, ending in a Court of Appeal decision this year on good faith. So in 2014, SATVA, the Supreme Court essentially said, look, the proper approach to a contract is a practical common sense approach. So the court said, you got to get away from this really legalistic approach, although the court is supposed to look at the words and determine what those legal words mean. But if there's any ambiguity, the court looks at it from a practical common sense approach. So if some of the words legally don't make sense, then the court will say, well, we're not going to apply that part. In Bazin, it said parties to a contract are required to act in good faith in the performance of their contractual obligations. And that's come up a lot this year in 2020 because of COVID, where we have parties approaching us and saying, well, look, this contract kind of doesn't deal with COVID, but, you told us that a practical approach is required and that we are to act in good faith. And so the question becomes, is each party acting in good faith when they're trying to perform their contract and there's difficulties with COVID and other issues? The next sort of major case was SA and Metro Vancouver, where in 2019, the Supreme Court of Canada looked at what are we looking at when we're interpreting a contract. So essentially, the court says, let's look at the factual matrix. In other words, what are all the facts surrounding the contract? But not how we look at it today, but how those facts were looked at the date of the contract. So if the contract was done 5 years ago, say pre-COVID, then what knowledge did the parties have? What was the factual matrix, the facts surrounding the entering into the contract? And so the court will today try to say what happened 5 years ago in the industry that made the parties enter into a particular clause in the contract. So what it's telling us is you're looking in hindsight at when the contract was made. You're not looking on today's values, for example, or today's facts. So that brings us to sort of the only real case this year dealing with contracts. And this dealt with a clause that said, the one party can assign the contract. This was a lease, but they need the consent of the other party. And so they said that the refusal to consent to an assignment of a lease was held not to be in good faith, and the court ordered Parkland, who was refusing to consent, to consent. So the court, says, okay, you've got freedom of contract. You have to do a practical common sense approach. You have to act in good faith, and we're looking at all the facts. They did that and said there was no good reason for Parkland not to consent. So what you should get out of all these cases is contract is a contract is a contract. It's going to be extremely important. The courts are going to likely enforce it 100% of the time, 95% of the time. If there's an issue, an interpretation, they're going to apply the rules they've set out in the Supreme Court from 2010 onwards, and they expect parties to act in good faith. So that seems to be the current state of the law, and certainly in Ontario, that the quickie case becomes very important in how we deal with situations. So in terms of court delays and why we are still very much in favor of arbitration as opposed to courts, even before COVID-19, even before March 16th, 2020, and everything being put on hold, the court system was already in dire straits, being behind in terms of getting anything heard. If I had a case come in to me today, I gave the client an opinion, and then I would, say, okay, you can commence a lawsuit. It would be likely 2 years before that case was heard. We've had cases that have been scheduled for trial, for example, for last year, and the week before trial, they said, we don't have a judge for you. So we're going to put it over to next year. Well, they put it over to this year, and now everything was on hold, so it's now not scheduled until next year. That really doesn't happen with arbitration, because in arbitration, you've got essentially a private judge, a judge who makes the decision. That's not mediation. Mediation is where you hire someone to try to mediate the issue, the dispute, and the mediator does not have authority to make a decision. They just have to get the parties to agree to a resolution. Arbitration is essentially like a hearing, a court hearing, but it's done privately. And there are lots of arbitrators out there, and I'm an arbitrator as well. I have my arbitration designation, so I can hear a case and make a decision that is binding upon the parties. Now, the thing about arbitration is that the parties have to have an agreement that they will arbitrate. It's either done in a contract where there's an arbitration clause, and it should be well drafted so as to avoid issues, or the parties, after the issue arises, agree to arbitration. And generally, it's better, of course, to have the arbitration clause in the contract. So what happened with the court system with COVID? Well, everything was put on hold March 16th to about the 1st of September. So any limitation periods were put on hold, any court procedures were put on hold. Now the procedures they're really governed by each province, or by if it's a federal case, by the Federal Court of Canada. And for example, Ontario only allowed very urgent matters, and that to demonstrate that something was urgent was practically impossible. The courts were hearing only criminal cases and family law cases that were urgent. And they said, we're going to proceed by Zoom or other virtual platforms agreed to. And in effect, some cases out this year where one of the lawyers says, well, I don't want to proceed by Zoom. The judge said, nope, in this case, we're going to do it by Zoom, including employment cases. Starting September 1st, some of the provinces eased the restrictions. On Ontario, for example, September 15th, Quebec, September 1st, the limitation time suspensions were removed, although there are still huge backlogs in the court system. So we don't expect that to disappear for years and years. As I said, if I started a case today in court, don't expect anything to be heard for 2, 3, possibly 4 years because of the backlog. So they're all now trying to catch up. Again, arbitration is a way to avoid the delays. We've found that an arbitration can be a hearing usually gets heard between 3 and 6 months from the date of start. Again, the benefits is that it's quick, it's confidential, it's now becoming cost effective. Although you have to pay for the private arbitrator, that cost is actually cheaper than appearing in court multiple times just to explain why the court doesn't have any judges or why additional steps have to be taken. There are limitations on arbitrations, of course. The clause has to be properly drafted, and then there are some additional limitations which resulted from the Uber and Heller case, which I'll talk about later. So let's look at employment contracts. What's happened in employment contracts this year? So the major case was the Ontario Court of Appeal in a case called Waxdale and Swagan, North America. And essentially, this case said the termination provisions in a contract that provide for anything less than the minimum requirements under legislation are void. So Mr. Waxdale was terminated without cause, and he was given a minimum amount under the Employment Standards Act. Now, the interesting part is that the clause that dealt with the termination without cause and gave him the minimum amount under the Employment Standards Act was in essence invalid. But if you remember from the line above, he was terminated without cause, and that clause was fine. But the court said because that whole clause has a part that offends the ESA, the whole clause is deemed void. So if you have a clause and the employee, in this case, it had a clause that said if the employee is guilty of willful misconduct, disobedience, or willful neglect of duty that is not trivial and has not been condoned by the employer. So this clause is actually wider. It's in the contract. It's wider than the Employment Standards Act. This is the Employment Standards Act clause, but the clause in the contract of Mr. Waxman was wider, so it was void. So you have to really be careful with drafting termination clauses in employment contracts. And then as well, we're going to see the Uber decision a little later on, which adds another layer of complexity. So last year I spoke on the Driver Inc., and this is an article from 2019 where the CTA calls to action, says, look, the government has to prioritize trucking issues like Driver Inc. Well, in fact, the government has moved to limit Driver Inc. To the point where we are telling clients you cannot have any drivers in Driver Inc. So what does Driver Inc. mean? So I'm just going to go backwards and tell you a bit about, sort of the hiring situations. You can have an employee, and that's a driver who's employed as an employee on payroll. Source deductions are taken from his pay. The next level is a dependent contractor. In other words, they are, in effect, probably have an agreement that says they're independent, but in fact, they only work for one company, and they're called a dependent contractor. Then you have an independent contractor, which is a truly independent. That driver works for multiple companies as an independent. And then the Driver Inc. model is essentially where a driver incorporates him or herself, but doesn't own any tractor or lease any tractor, and in essence, he really only works for one company. And the Driver Inc. model is what's causing a lot of issues for the industry. So RevCan treats it in a certain way. They really don't care too much about it as long as the employee pays taxes. And a Driver Inc. model employee actually pays more taxes than an employee, even though the drivers out there are misinformed and think they would get a benefit from being incorporated. The only benefit they get is if they are incorporated, the employer does not take source deductions or tax deductions from the pay, and then they don't submit those to the CRA. That's where they get the advantage, because if they're actually paying tax as an incorporated driver without lease or ownership of a tractor, then they actually have to pay more. Workplace Safety and Insurance Board is the agency that has been going after Driver Inc. They want their premiums. And the second sort of agency that is really tracking it is now starting, since the CTA made submissions, is starting to really come down hard on this area, is the Employment and Social Development Canada, ESDC. In other words, the equivalent of the Ministry of Labour in Ontario. This would be the federal body that deals with employers and employees in federally regulated industries. And trucking, once you cross the border, is a federally regulated industry and subject to the Canada Labour Code. So an employee, again, be they part-time or full-time, would have income tax, CPP, EI deducted. The WSIB would be paid by the employer. They get a T4 slip, and they're subject to either provincial labor legislation or, as I said, if they're a federal undertaking, the Canada Labor Code. Dependent contractor usually owns or leases his or her own truck. However, he or she only works only for one company or related group of companies. They may be incorporated or they carry on personally. They may be paid by hour, mile, route, combo. So the CRA treats it as if they have a personal services business and pay corporate tax accordingly. ESDC treats them as an employee, and WSIB treats them as an employee. So if you have a contractor that you think you've signed an independent contract with, but they only work for your company, really they're an employee. An independent contractor, on the other hand, works for more than one company. That's the key, and has the ability to pay their own premiums. They may have their own CVOR or insurance. They pay corporate tax, typical with a corporation. So CRA says that's fine. You can pay the reduced tax rate. ESDC says you're truly an independent, and WSIB says you're truly independent. Again, the key is that they have the ability to work for more than one company. Driver Inc. Is incorporated, could be paid a rate per shipment, or per mile, etc. Does not own any equipment. Tax rate is the highest tax rate, even higher than employee at 33%. And ESDC considers them an employee, and WSIB considers them an employee. So what we have is, the consequences for employers is that they're an employee, and dependent contractor and Driver Inc. They're all employees. And so you have to submit income taxes for them, CPP, EI, etc. And if you don't, you can be penalized for 7 years. So what does this really mean? It means that if you have an independent contract agreement with a driver, and you think that driver is an independent, and you've been paying them as an independent, but in effect they only work for you, and the contract is such that it looks like they only work for you, that driver can turn around and, if you dismiss them, can make life hell for you as an employer, because they will be deemed to be an employee, and you owe them for all these back taxes, back money. ESDC also says they're an employee. you can't terminate them if they've been with you for more than a year. There's a case called Atomic Energy in Wilson where you can't terminate an employee without cause. In other words, you have to terminate them for cause. You can't terminate them just because you don't like them anymore or you don't want them anymore, and you can't just pay them out. So the ESA also obviously is going to come into play. So the consequences for employers are huge. WSIB will come back and calculate the premiums you should have been paying plus interest of 6% and non-compliance charges of 5%. You can also bring a criminal code charge with fines of $25,000 or 6 months for individuals and fines of $500,000 for corporations. So pretty significant penalties. We know that at least 3 companies have received charges of $250,000 penalties for driver Inc. violations. So what's the law? The law in terms of cases as to whether someone's an independent contractor or not are set out in a number of Supreme Court of Canada and Ontario Court of Appeal cases, and I list them on this slide. So the first one is 71122. In that case, in 201, they looked at who has control, like who controls that driver. The other sort of cases look at, who owns the equipment, who has the chance of a profit, risk of loss, and they looked at various tests. The last one was last year's modern cleaning, and the Supreme Court of Canada basically said who has the business risk. Who faces the business risk? So to be truly independent, the contractor has to have all the business risks, not just the loss risk, but the business risk. In other words, whether they succeed as a business or not is all on them. Pretty high standard for a test. The side effects of having a driver Inc. or a dependent contractor that's not truly independent is that directors and officers are personally liable. Even if you have a company, if you're an officer or director of that company, you're personally liable for wages, source deductions, environmental damage, and breach of trust obligations if you're a load broker. And from the issues obviously are back pay, vacation pay, and other issues. So in terms of your broker, then you have to keep, in Ontario, for example, a separate trust account for monies that are owed to a carrier. And if you don't do that, there could be a breach of trust argument against you personally as an officer or director. So what are the current trends in this driver Inc. issues? I spoke a bit about this last year, but what have we seen this year? Well, we've seen 2 law firms in Ontario that are representing drivers who are driver Inc. drivers, and they are seeking vacation pay, overtime pay, wrongful dismissal. The risk is that you may, as a company, face class action. ESDC are now ramping up their investigations and putting penalties on driver Inc. Employers. So far, this year alone, there are 58 reported cases now, albeit mostly our unions, challenging this independent contractor issue as to what is or is not an independent contractor. Now, we still advise clients and still draft independent operator contracts, but we tell them that they're probably 96% good, but there's always a 4% chance the contract won't stand up. Now, our contract has what we call the key terms that allow the driver to operate for other companies. Whether the driver does or does not is another issue. It allows the drivers to placard their tractor so that they could work for multiple companies. It has other little neat key sections that hopefully will allow a court to say, no, that you're an independent contractor, and the fact that you work most of the time for one company doesn't make you a dependent contractor. So we'll see how that goes. So I mentioned earlier the Supreme Court of Canada Uber decision and how it affects employment contracts. So in Uber, all the contracts with Uber drivers had a clause that any disputes were required to be resolved by arbitration in the Netherlands in ICC arbitration, so that international arbitration. And ICC arbitration is very expensive, and having to do it in Netherlands is also obviously very expensive, and a single driver has difficulty if they have a dispute with Uber to do it in the Netherlands. So in effect, the Supreme Court said that clause was unconscionable, and so they wouldn't uphold the clause, despite the fact that in Turkon they said there's freedom of contract. Freedom of contract, they will not enforce. The courts will not enforce unconscionable contracts, and the court in Uber set the two new elements for unconscionability. Previously, there was a different test for whether a contractual term was unconscionable. The Supreme Court of Canada essentially set out two new elements. One, inequality of bargaining power, or an improvident bargain. So inequality of bargaining power was described by the Supreme Court of Canada as the presence of a bargaining context where the law's normal assumptions about free bargaining either no longer hold, substantially true, or are incapable of being fairly applied. In other words, the Uber was so powerful and the driver so lacking in power that there was really no bargaining. And the court went on to cite examples, which is rare. The Supreme Court of Canada never cites examples, but they did. So one was where a weaker party signs a contract out of necessity to prevent negative consequences. So I had no choice. I had to sign it. Otherwise, this would happen. Or where that a person can't appreciate the terms due to dense or difficult language. So those are two examples the court gave of inequality of bargaining power. The second part, of course, is an improvident bargain. This is the second test, and the court described it. In essence, the question is whether the potential for undue advantage or disadvantage created by the inequality of bargaining power has been realized. An undue advantage may only be evident when the terms are read in light of the surrounding circumstances at the time of contract formation, such as market price, the commercial setting, or the position of the parties. In other words, the court will look at the contract, apply all the rules I've stated in the previous 5 cases, and then say not only was the terms of the parties, there was an inequality of bargaining power, but it was also an improvident bargain. In other words, when you look at all the circumstances, this doesn't make sense, from a financial perspective or from a viability perspective. So this decision, although it's only with Uber and Heller, it's going to impact all contracts. So now we have to keep in mind when you're drafting a contract to figure out do the parties have such an equality of bargaining power, and is it a bad deal that for one side that the court won't uphold it. So the other big aspect this year of looking at all these contracts is also looking at force majeure and force majeure clauses on old contracts. Force majeure is actually a contractual term, so it doesn't exist in English common law. It exists in French, but not in English common law. There's no concept in common law of force majeure, so it cannot be implied into a contract. There actually has to be a term in the contract dealing with force majeure. And force majeure clauses are going to be interpreted strictly because it affects a party's rights. And each term must be considered and looked at precisely. The interpretation involves an objective test. An objective test means it's not what each party thinks it is, but what somebody who's on the outside looks at it and says, this is what it means. It's applying what a reasonable person would read as to what the clause means. So most force majeure clauses are open in the sense that they will not necessarily specify all the force majeure risks, but may say, it's acts of God and similar things. So, but it's easier, of course, in a contract if you actually list what the force majeure events are. For example, pandemic. And if you look at most force majeure clauses, the word pandemic is rarely found. Here's an example of one that shows you what the triggering events are. So it says event of force majeure means an event beyond the control of a party, which prevents a party from complying with any of its obligations under this contract, including but not limited. And here's where they start listing everything. So you'll see in this one, there really isn't an example of pandemic. There isn't even, I don't believe I see it in here, epidemic, which some force majeure clauses have. And let me tell you, this year, that was the most important sort of item in contracts with force majeure, because everybody was trying to say, well, I don't have to comply, or I can't comply with the contract. In terms of what you could add to the previous one in terms of lists, 1.16 as acts or threats of terrorism, you could add pandemic, epidemic, and then you have this kind of overall catch-all or other unforeseeable circumstances beyond the control of the parties, against which it would have been unreasonable for the affected party to take precautions. In other words, you can't kind of anticipate something and not put it in. So you could also, obviously, what we see in other wordings are, plague, public health emergencies. The closer it is to the event that you actually experience, the better. In terms of the wording, you also don't necessarily have to see the word force majeure. For example, in the OOCL Bill of Lading, Clause 31, it actually, I call it force majeure here, but it doesn't use the word force majeure in the document. It just talks about the rights. This is without prejudice to the rights of the carriers in the event of war, hostilities, port congestion, strike, regulations of government authority. And so they have, in essence, options. And this, in effect, is a force majeure clause of a kind, but doesn't say force majeure. So you always have to look at the entire contract to make sure there isn't a clause that is equivalent to force majeure. In terms of these clauses, they normally require notice to be given. So we had a very recent case where a client came to us and said, well, we had a force majeure event, we shouldn't have to pay for this and that. And I said, well, did you give the other side notice that you had a force majeure event? And the answer was no. And I said, well, your contract kind of requires notice to be given within a number of days, 10 days. And so what the notice and consequences clause also has, it says it'll suspend the contract for a certain number of days. And then if they don't fix it, or if you can't fix it, one party can terminate the contract. The clause also requires you to take best steps to mitigate the loss. So here's a sample notice and consequence clause. You have the no liability, you have the best efforts to cure, and you have the right to terminate. In this case, it's 90 days. If you can't, if the force majeure lasts in excess of 90 days, the non-defaulting party can terminate the agreement. So force majeure is different than frustration. So frustration is in fact a common law right, and doesn't have to be in the contract, but it comes into play when, like a force majeure, the performance of the contract becomes impossible. And this is different than the actual force majeure, because this is a little tighter and stronger. It's not dependent on an event like pandemic that's listed, but rather the impossibility of performing the contract. It's not enough the contract becomes more onerous or more difficult to do. As long as it's possible to perform, then there's no frustration. So the party has to show that the original purpose of the contract has been frustrated. A couple of examples. 1966, Court of Appeal of Alberta. The defendants agreed to rent out a music hall to the plaintiffs for 4 dates. This was for a concert. Now, the hall was destroyed by fire through no fault of anyone. So, in essence, it was impossible to perform the contract. So, the Court of Appeal said there's frustration and the parties are excused from the contract. There's very little case law about whether pandemic can frustrate the contract. There's a Hong Kong case during SARS, and in effect, the court said the 10-day isolation period did not change the contractual obligations of the parties. It wasn't a frustration. It wasn't becoming impossible, and so they held that it was not frustrated. Similarly, there's a Canadian case with Bell, TELUS, same effect. So we looked for cases. I looked for cases for this year and found one that's interesting, and this is Van Hopen and Chilliwack Golf and Country Club. It's a BC case in this year in September. This is a contract for a wedding venue. It did not contain a force majeure clause, and it didn't have a clause as to the minimum number of guests, but Van Hopen wanted the deposit back. And the court said nope, and the basis was frustration. The court said nope, the contract's not frustrated. You could have had a smaller event with a smaller number of guests, and because the contract didn't specify that you had to have a facility and 100 plus guests, you can't plead frustration because the contract could still be performed. So that's one of the few cases out there in the English language. There's a lot of Quebec cases based on the civil code, which is slightly different. That's a code issue. So lastly, so that's it for frustration and for force majeure. I'd like to deal now with sort of like any trends in two additional areas. One is the carriage of goods by road, and the other one is the obviously the insurance. So in terms of domestic law, obviously each province has requirements for bills of lading. Just keep in mind that the territories, Newfoundland, PEI, do not have legislation dealing with a carriage of goods. So I urge you to all issue bills of lading, whether or not you think you're carrying goods for an ocean carrier and you're using their bill of lading. Issue a bill of lading. Most provinces that have legislation require either the shipper or the carrier to issue a bill of lading, and it depends on the province. Ontario doesn't deal with bills of lading. They got rid of the language of bills of lading, but they deal with contracts of carriage. And despite what most people think that haven't looked into this, Ontario still requires a bill of lading, or at least a contract of carriage that basically sets out everything that a bill of lading has. And so if there's no statute like in PEI and Newfoundland, then you as a carrier are the insurer of goods. You can't limit liability. There's no defenses such as inherent vice, and your valuation of the loss is affected because the statutes and set out that the value of the loss is at the time and place of origin, as opposed to the common law, which is the value at the place of destination. So it affects how valuation is done. As I said, the Federal legislation says that the law that applies is the law of the province in which the transport originates. And then if you don't have a province that has legislation, it's what's agreed to by the parties. In other words, you have to issue a bill of lading. Strongly recommend you issue a bill of lading. We found a number of cases this year where the trucking company or the load broker didn't ensure that a bill of lading was issued. You got a load confirmation sheet, you've got, inventory sheets, you've got packing slips, but no one issued a proper bill of lading. And when I say proper, it has to have obviously a box for the value of the cargo, and also a position on the legislation applies, a clause. So what we've seen is, because of I guess COVID and other issues where money's tight, everyone's suing and taking advantage of the fact that if you've missed out the I or crossed the T and you don't issue a bill of lading, you're not going to be able to limit liability, and so it's costing more in terms of litigation. And so to be safe, issue a bill of lading. Last issue I want to deal with, and I'm cognizant of the time, is insurance issues and the trends we've seen this year. So what we've seen is some rates are going up. Insurers are really taking a hard look at contracts. And generally, unless they've approved the contract, they will only cover the liability if you issue a bill of lading. They'll cover a trucking company or for the $4.41, but if your contract calls for full value, they're not going to pay that unless they've approved of the contract in advance. So the insurers are really taking a hard look at contracts. So as a result, when we do look at insurance, our work, we get requests to review contracts all the time. And also, if you're a load broker, they may not cover load broker liability. It might be excluded. So you have to really look at the insurance. What we've seen is a lot of claims for, in essence, the cargo is not damaged, but there's a fear, what I call a pandemic fear, where somebody doesn't want the cargo because they may have been in contact with, the pandemic virus. Well, obviously, there has to be proof that the cargo is damaged. Fear of damage is not covered by as a liability for carriers. And there have been a lot of these cases this year, so it's it's time again to look at your insurance contract. And as I said from the beginning, this is the trend. Everybody's looking at their contracts, wanting to be protected for what can go wrong. In essence, that's my presentation, and I thank you all for your attention.